platform in charge of Eastern Uganda. I will again come back in the capacity of Chief Opposition Whip.
To the law by the move I appeared before you. For the sake of democracy and good governance, the National Unity Platform opposes this amendment bill in its entirety, and we base our strong opposition to this proposed law on the following grounds and context. One, we believe that the bill violates the Constitution of Uganda and the established democratic principles. The bill in its current form unjustifiably discriminates against opposition parties and their members of parliament on grounds of their political opinion, which is prohibited by Article 21 of the Constitution of Uganda, which prohibits discrimination on grounds of political opinion, among others. And I can give examples. One, it discriminates against the leader of the opposition's business in parliament vis-a-vis the leader of the government's business in parliament. Article 108(1) of the Constitution designates the Prime Minister as the leader of government business in parliament, while Article 82(a)(1) effectively designates the LOP as the leader of the opposition's business in parliament. To achieve this, the party in government appoints the Prime Minister, while Section 8(1) of the Administrative Parliament Act empowers the main opposition party to appoint or to elect the LOP. However, Clause 2 of the bill intends to introduce a discriminatory approach whereby the LOP would be elected by all MPs of the various opposition parties in Parliament, yet there is no similar requirement for the Prime Minister to also be elected by those who subscribe to his or her political party. Furthermore, Clause 3 of the bill, which introduces additional grounds for removing the LOP from office, is discriminatory in the sense that these grounds would apply only to the leader of the opposition, but not to the leader of government business, who is the Prime Minister, yet the two play parallel roles. Providing for the removal of the LOP by resolution of all opposition members of Parliament and not providing for the same for the leader of the government business is not only discriminatory, but would be a direct affront on the opposition. Number two, it discriminates against the Chief Opposition Whip vis-a-vis the government Chief Whip. And Section 14(1) of the Administrative Parliament Act provides for the appointment of a government Chief Whip by the ruling party from among its members. Please note the word appoint, that's what it provides for. Section 15(1) of that same act provides for the appointment of the Chief Opposition Whip by the opposition party having the most members of Parliament on the opposition. However, Clause 3 of the additional amendments now introduces a discriminatory approach whereby the Chief Opposition Whip, unlike his or her colleague on the government side, would be elected by members of the opposition, which would be discriminatory and wrong. Worse still, whereas the bill is being touted as a tool for increasing efficiency in the opposition, it proposes that the new role of the Chief of Opposition Whip would be to ensure the attendance, participation in proceedings and voting in Parliament by all members of opposition parties in Parliament, contrary to the prevailing situation where each opposition party has its own whip. Effectively, that means that the logic or reasoning would be that there should be one whip for all opposition parties, yet the ruling party will have its own whip, which is not shared with any other party. Number three, the proposed law undermines the autonomy of opposition political parties, thereby weakening constitutional checks and balances. The bill disregards Uganda's constitutional framework, which envisages a multi-party system where each political party retains the authority to manage its affairs. It specifically infringes on the right of the main opposition party to self-regulate and appoint its leadership in Parliament. Yet, in nascent democracies like Uganda, each political party must retain the autonomy to select leaders who best represent its ideals and policy positions. By proposing provisions that allow multiple opposition parties to participate in the selection and removal of the LOP, the bill unconstitutionally attempts to circumvent the role and influence of the largest opposition party and usurp the will of the citizens who voted for it ahead of any other opposition party. And I think this point has been made that under a multi-party dispensation, the Westminster system, the presumption is that there is a party in government and there is a party in opposition. The main party in opposition, therefore, effectively forms government in that sense. And that is why there is even a shadow cabinet and all those. This bill's provision This would undermine the largest opposition party's ability to assert its role as a primary check on government authority within Parliament, as well as its ability to hold parliamentary and other government officials accountable. It would also compromise the LOP's role by enabling the ruling party to influence decisions through members who may be more sympathetic to the ruling party's interests. Secondly, there is a likelihood that opposition MPs may be bribed or compromised or unduly influenced by government to vote a LOP agreeable to the ruling party. We all are in Uganda. We are not from Mars, Honorable Chair, and we know what has been happening in this country. There have been several reports of MPs being compromised to pass controversial laws and proposals by the ruling party. We are concerned that even this time around, the ruling party may seek to compromise opposition MPs to vote certain candidates for LOP whom the ruling party finds agreeable, which shouldn't be the case under a multi-party system. Honorable members, I invite you to consider ERY'okukyusa elections, for example, and you see it is strange that the largest opposition parties for long have not had a chance to send representatives to ERY'okukyusa. You will recall that in 2016, the chairman of NRM, General Museveni, publicly said that there is good DP and bad DP in an attempt to influence the voting of members of parliament in that ERY'okukyusa election. And indeed, those who are considered good DP found themselves able to sail through under that arrangement. Not all MPs considered opposition actually oppose the government. That's also another point. It is misleading to suggest that members of parliament who did not come to parliament on the ticket of the ruling party are actually in opposition. In the case of NUP, for example, honorable members, in the case of NUP, consider the case of Honorable Twa Kagabo, Honorable Jimmy Rwanga, and others. Although these members came to parliament under the NUP ticket, they have been categorical, stating it publicly that their current allegiance is to the NRM, to a point of attending NRM caucus meetings. Now, members, are these the people who would be expected to elect the leader of the opposition in parliament? Would these kinds of people be expected to objectively refrain from moving countless motions to remove the LOP on frivolous grounds? People who have already indicated, although they are seemingly on opposition, but their allegiance and interests are elsewhere. In this regard, therefore, Honorable Lumu seeks to hand over the opposition to the NRM or any other ruling party using this absurd proposal. Worse still, it would be absurd in the present context to assume that every political party that is not in power is actually in the opposition. What do you make of the Democratic Party, for example, or a section thereof, which currently has a cooperation agreement with the NRM? Or the UPC, which General Museveni recently said are very good allies to the NRM. Should a political party in cooperation with the ruling party participate in electing a leader of the opposition, whose cardinal role is to keep that same government in check, it would defeat basic logic. We also invite this committee to reflect on the reality that political parties in the opposition are not homogeneous. Although we are all branded opposition, currently we have distinct ideologies, policies, and approaches to different governance issues. You cannot suggest that opposition parties are homogeneous, therefore. Even though they may operate within the same political system, each opposition party represents a unique set of values and priorities. This diversity must be guarded when deciding the opposition leadership in parliament. Failure to do so would impose undue influence on the internal decision-making processes of the main opposition party, thereby hampering the multi-party system that the Constitution was deliberately designed to protect. Inadequate consultation, the manner in which the bill is being fast-tracked through the parliamentary processes.
Vote candidates or parties of their choice. 2, there are lots of consultations that go on in the background with various stakeholders before the final position of leaders is brought to the House for approval. A case in point, Mr. Chair and the colleagues, is the NRM cabinet that has a cocktail of political parties in its cabinet who are appointed solely by the president, whereas in the opposition, shadow cabinet is constituted from the entire opposition membership, irrespective of party affiliation, by the official opposition party
of the National Resistance Movement Party in Uganda. I have been accompanied by the Director Legal, Comrade Enoch Barata. I also have with me Commissioner Jane Alesemera, who is a commissioner with NRM Electoral Commission, and Comrade Awich Paula is the Director External Relations at the Party Secretariat. The rest are our support staff. I have, you introduce yourself. Should I introduce this matter? On my part, Mr. Chairman, on behalf of the party, the National Resistance Movement Party, in its thinking, in its philosophy, wouldn't want to constrict itself into a thinking that makes everybody feels like we are not giving them a chance. We, as a party in government, we contested for leadership. Our manifesto was voted for, and just like another party that came to contest. And we are in leadership because of the popular vote by the people. And it is in our interest that we have opposition which is organized enough to challenge our activities of governance. In a way, we think that it's better to deal with an organized opposition. It's better to deal with an opposition that think through what it's supposed to oppose. And so critical thinking under a multi-party political dispensation, we know there are many other political parties that equally so have members represented in Parliament, and therefore we feel all of them should participate in the governance process of this country. Now, having said that, we also know that the Constitution is very constraining, that parties contest for governance and a winning party is voted for based on its manifesto, and the first runner-up becomes a leader of opposition. That has been the practice. And with the administration of Parliament, a leader of opposition is picked from the party that comes second in the national election. Now, we've been debating and seeing to what extent would such represent the interests of all other political parties in Parliament which are in opposition? And have we been able to get their views in many of these critical national issues? When a leader of opposition speaks in Parliament, does he or she speak on behalf of other political?
Thank you, honorable members of the committee, for inviting us. Indeed, I reiterate the appreciation expressed by the Secretary General for us being here. We have looked at the bill, the Administration of Parliament Amendment Bill 2024. We have looked at the objects of the bill, and we will comment on them as the matters on which they comment arise. We have also noted that there are some additional proposals in the bill which do not seem to be captured by the object of the bill. They appear to have been proposed by the mover of the bill subsequently. Nonetheless, as that is a matter entirely of procedure, we shall still address them, and we leave the rest of it to the committee and to Parliament. So on clause 1 of the bill proposes to change the definition of the leader of the opposition. The current act is that the current law is that the leader of the opposition is that person who is elected by the party in Parliament with the highest numerical strength. I think that is section 11. I must have misplaced my act somewhere. Now, we believe that to cast the leader of the opposition as such would go against the established traditional parliamentary systems in most of the Commonwealth jurisdictions. the leader of the opposition is typically a leader chosen by the largest political party not in government, and that position typically exists in multi-party democracies. Now, in fact, in other jurisdictions where it is completely a parliamentary democracy, the leader of the opposition naturally is the leader of the other party that has come second. But in our case, because we have some sort of hybrid, the leader of the opposition is not necessarily the leader of that party, but is elected or selected by that party that has come second. But I think for want of better language, the law talks about the biggest numerical strength in parliament, because the leader of opposition is elected in parliament. So that office is established by Article 81A of the Constitution, so it's a constitutional office. And we hold the view that the current definition aligns well with multi-party democracy. We do not think there is anything wrong with it, and we shall explain that later. Clause 2 is the one that proposes to have members of all the political parties in opposition in parliament elect a leader of the opposition. Now, if we go back a little bit to the definition, the definition is assuming that the leader of the opposition is supposed to serve that party which he leads, which is not correct. The leader of the opposition is an office, it is established, it is there regardless of which party is in power or of which party comes second. So, but the office itself is established as the leader of the opposition with specific functions that are not delineated or are not limited to achieving the objectives of that political party. So we maintain that this runs contrary to multi-party democracy and negates the popular vote. When you look at the spirit of the law, the spirit of the law is that in a multi-party democracy, the party that achieves the biggest number of the popular vote forms government. It is that same spirit that says the other party that next achieves
the two tribunals. Now, this is a rationalization bill, which is abolishing certain established agencies. So, the two that are being abolished is the Tax Appeals Tribunal and the Electricity Tribunal. Now, I do not know where the honorable member finds the evidence to prove that this tribunal is an omnibus tribunal. For instance, we have got the one that deals with procurement. We have disputes that arise out of procurement. The National Tribunal will not be dealing with those. So maybe the honorable member can tell us where the implication is.
Clause 42.
Yes, clause 42, we have it here.
Where any act provides for the establishment of a tribunal, the National Tribunal shall be taken to be the tribunal established by addiction. We all want a clean law. And so we are raising this to avoid any controversies that may arise. Honourable Minister, there is already, you may not be privy to it yet, but there is already a challenge between the Ministry of Lands and the National Planning Authority when the National Planning Board was moved to National Planning Authority. So there is already, we're supposed to do what, when should it be done? Now, from experience, we need it cleaned so that we avoid. Now, the last issue, Honourable Chair, I had the floor, and I'm concluding. I am concerned, like the way Honourable Sechitoleko raises it, how prepared is the ministry to accommodate these agencies? You seem to be speaking about work in progress, and yet we are at the tail end of it. We have had challenges with institutions which have already been
merged. There are certain pertinent issues that affect day-to-day life of the workers that have not been addressed. And it's our humble wish that these issues be attended to cleanly so that we get better every day when we take these decisions. Thank you.
Mr. Chairman, may I propose that when this committee is sitting to do its work, please invite somebody like Mr. Okirik to be with you so that we work seamlessly. Now, I cannot speak for the other ministries, but I can assure you that as the Ministry of Justice, number one, we are really a service ministry. Fortunately, 90% of us go through the same training, and that's why it is a different kind of ministry. The majority of the people there are really lawyers. Whether you are the Attorney General, whether you are a state attorney, we all know. It's only our permanent secretary who is a geologist. But we may make him a honorary counsel. Now, finally, I can tell you, we came here before you talk about marriages, registration of marriages. I can tell you, we have been working very closely with the Ministry of Internal Affairs. So I really want to say, don't project the conflict between National Planning Authority and Ministry of Lands and make it appear as if we also have to answer for it. For us, as Ministry of Justice, whenever we are supposed to work with anybody, we make sure that it is not about flying little flags, but it's about ensuring that we take a whole of government approach. As I talk now, the staff of URSB who are in charge of marriages and so on have been moved to NIRA as authorized by you. And but the facilities for the marriages are actually in the URSB building, because that's where the red carpets are, the nice chairs and so on. I don't think marrying couples want to go to Kololo Airstrip, which is basically a site under construction for their weddings. So allow us to speak strictly about the laws that relate to us as Ministry of Justice, because you will infect us with the other diseases from other ministries. We can only promise that we are going to, I will call the Honorable Nabakova, I'll talk to Professor Pamela and tell them that Parliament is worried about their quarrels. But for us, we have no quarrels. And I can assure you, when you pass these bills, you will not hear of any quarrels.